And then at the other end is that whatever transgression happens, can you change that slide for me, please?
You have the clicker.
I do, and it's not clicking. The other end of the spectrum is that this really doesn't have anything to do with criminal law. That all you've got here at the most is violations of lesser criminal statutes that apply to registrants, record-keeping violations, that sort of thing, and it certainly shouldn't result in felony convictions. And as usual, the truth probably lies somewhere in between the two. Not that practitioners, by and large, are the same as a crack dealer, and not that criminal law has no role to play in it at all, certainly when you've got this. All right. Can you change it 3 or 4 ahead? Do you have control over it? It was bound to happen. If you've ever seen the Terminator, the machines rise up in the end. That's what is going on here. We should probably just vacate. I'm going to go on to keep us on track here, and as soon as they get the bugs worked out, maybe they can catch up on the slides there. Luckily, I've got them printed out here. The beginning of this story, and again, I'm coming back to Ruan, and in case you leave or go to sleep, here's the holding in Ruan. To prove a criminal charge of unlawful prescribing such that it becomes unlawful distribution, it is no longer enough to prove that a practitioner prescribed and that prescribing was outside the bounds of the law. What the Supreme Court held was the scienter, the mens rea, the criminal intent element, doesn't go to the prescribing. It's not enough to show that they knowingly, intentionally prescribed. You must show that they prescribed and knowingly, intentionally did so outside the bounds of the law. Your first blush at that may be to think, well, wait a second, how do you, short of a brain scanning machine, how do you ever prove intent? But I think a little reflection will put you exactly where I wound up. It's done all the time. There are all sorts of criminal statutes that hinge on intent, and intent is generally proven by external circumstances capable of proof from which you infer what their intent was. And I remember when I was a baby lawyer trying criminal cases, when you're trying to explain this to a jury sometimes, you pose a question to them. How can you tell where a quarterback in a football game intended to throw the ball? Look and see where they did throw it. I think that's usually true, but some quarterbacks perhaps not. But by and large, wherever the ball goes is where they intended it to go. And so Ruan is a criminal intent case. It makes the burden on the prosecution a little more focused. I won't say higher, the burden is always beyond a reasonable doubt, but it shifts the burden from simply being able to show that, from simply being able to require that they show beyond a reasonable doubt that they knowingly and intentionally prescribed, to showing that they knowingly and intentionally prescribed unlawfully or outside the bounds of the law. So, as I promised a moment ago, the genesis to all this dates back to 1975, this Moore case. And again, the Uniform Controlled Dangerous Substances Act was in its infancy at this point. And there was a large contingent of people who would tell you, look, if you're authorized to prescribe drugs and you are a physician, that is between you and your patient. The law has nothing to say about it. The unlawful dispensing, the unlawful distribution, felony charges, those are for people who do not have authorization. And the Supreme Court knocked that aside unanimously in 1975. And the U.S. versus Moore, honestly, it's by and large a fairly paradigmatic overprescribing case where you've got some pretty horrific numbers. You've got evidence that the doctor was putting a lot of controlled substances on the street with very little or no safeguards against diversion, very little or no patient examination. So this was a good vehicle for the U.S. Supreme Court to hold, as it did, that under the right circumstances, criminal charges that normally attend somebody who is selling street drugs can be applied against a practitioner. I joined the Oklahoma Bureau of Narcotics in 1989, July the 14th to be precise. At that point, it was beyond dispute in the circles that I inhabited back then that a practitioner who violated their authorization under the law could be prosecuted this way. I wasn't a lawyer at that time when I joined OBN, and it honestly never occurred to me that that what I took just for granted had actually been the subject of a Supreme Court case back in 1975 that had to determine this. So that's where we begin. As I told you earlier, under federal law or any of your states, you will not find under the unlawful dispensing guidelines as to what is or is not lawful. This is the Code of Federal Regulations, or the CFRs, and it is there where authorized is defined as pursuant to a doctor-patient relationship, valid medical purpose, etc. So what is the problem here? And if it feels to you like I'm skipping ahead a little bit, I'm going to make up the time that we lost on the slide thing again a little bit. So don't worry, I'm a trained professional. You're in good hands. We're going to be fine here. But here's what we're talking about. Many of these prosecutions over the years have turned on expert testimony. Many of these prosecutions over the years, more included, come down to the defense position that, look, even if most of the witnesses you can put up on that stand think that I'm dangerous, this is just their opinion. Yes, I practice in unorthodox ways. I handle patients that have not responded elsewhere, and my medical judgment should prevail as to my patients, and I should be able to do this. By the way, I've got a license to do it from DEA and my state agency, versus experts on the behalf of the prosecution who testify that the methods employed by this practitioner are reckless, dangerous, and usually wind up with people being addicted and or dead. But the point that I'm making there is that they almost always turn on expert testimony from a physician, usually, doesn't have to be, who has never examined any of these patients. They, of course, will examine the patient records in preparation for trial. So as I referred to a moment ago, the provisions that we're talking about, and we're going to look in just a second at some of what I call the homicide statutes, manslaughter, murder too is usually what you're looking at, although it can even be first-degree murder in some cases. Since I'm standing in the state of Oklahoma right now, I pulled up the Oklahoma distribution statute, but those of you who are standing or sitting in other states watching this by live stream, those of you who are visiting here from other states, you'll find almost identical wording in your state statutes with very few exceptions. Title 63-2-401, except as authorized, and that's what we're here to talk about. The Ruan case is about the except as authorized, because you must now prove knowingly and intentionally prescribed outside of that authorization. There's the federal statute, except for the introductory line there above it, the wording is identical. And again, it's not an accident. This statute was a uniform law promulgated and then put out for the feds and for the states. Before that, there was the Harrison Narcotic Act of 1913. Was it, Mark? Were you? Ish, 1913, wasn't it? Been a while since I swam those waters. But there were a series of laws over the years, and the laws at the end of the 1960s, with its attendant interest in illegal drug use and drug addiction, brought us that Uniform Act back then. I've pulled up 7 of these cases. I'm not going to belabor each one of the facts, but I started with the most recent first. This, I'll call it a Bavyan case. It was just less than a year old. What I was actually looking for when I was updating the materials here was to see if anything had come out of the federal appellate circuit yet post-Ruan. They have not, but it's only been 4 months ago. Here you've got, this was a convicted felon. He was not a practitioner. He was a businessman and owned 2 drug treatment centers. He hired the defendant in this case, who was a physician, who'd been board certified in a couple of disciplines, had no prior substance abuse medical experience at all. He wound up pre-signing literally hundreds of prescriptions. When you look at these, there really are 2 or 3 categories that these cases fall into. It's either pre-signing prescriptions, or if they are signing them themselves, doing so with very little or no medical evaluation. That's the only way to keep the number of patients seen per day high enough to generate the literally thousands of dollars per day, literally millions of dollars per year, that these operations, and by these operations, I mean the ones that attract the attention of prosecution entities, that these operations tend to generate. Boy, it is terrible. I'm having trouble seeing that screen. I used to be the youngest guy in every meeting that I went to. And about 15 or 20 years ago, somebody called me sir. It struck me as odd at the time. I had no idea what it was portending. It was portending squinting at screens and seeing gray hair whenever I look in the mirror. The lead case is another fairly recent one. Here you have doctor and nurse. They were also husband and wife. I'm trying to keep from generalizing, but when you talk about a category of cases like this that share so many commonalities, you necessarily wind up speaking in generalizations. What you see, what I see, I suggest that you might too if you look at these cases. Typically, you'll see practitioners who are looking to dramatically increase their the money they're making. Lots of times there are practitioners who are in some sort of financial trouble. Sometimes you'll see that they've gotten in some sort of disciplinary problem for other infractions, making it more difficult for them to find a position of employment that suits them, and they'll fall into this kind of arena. Time and again, all you can do is see things the way it looks from your vantage point. My vantage point is as a 20+ year prosecutor and now a judge on a court of criminal appeals. I see things necessarily a certain way. The way that I see them here is that, of course, there are some of these defendants who have become greedy and chased the money, but way more often, it's almost like they fall into the clutches of unscrupulous people who are looking to make a lot of money and need a physician and their prescribing authority to do so. Those really are the two traps that I see over and over again. So the lead case, you've got this doctor and nurse, husband and wife. They put out over 1 million dosage units of controlled substances in 2 years. I think one of the kickers in this case, and it reminds me of a prosecution that I was involved in about 7 or 8, 10 years ago. In this case, you had a pharmacist and maybe more than one pharmacist and at least one spouse of one of the patients going to the doctor saying, my husband, or in the case of the pharmacist, your patients are seeing multiple doctors here. You're just one. They're doing doctor shopping. This is clearly drug-seeking behavior. What the prosecution was able to show here in the Lee case was that it didn't seem to alter the behavior one bit. The same number of patients were being funneled through the clinic, the same lack of attention as shown by exam times of 5 to 8, 9 minutes, and very often exactly the amount of the drug that the patient asked for is what was prescribed, very often the maximum amount. Those are some of the triggers that will bring an operation like this into the gaze of law enforcement. And Mark Woodward from the State Narcotics Bureau may be able to speak to that even more. But whenever you have just flow of patients, some of these clinics and some of the cases that I'll show you in just a moment here, they literally are lined up in the parking lot. Some of them appear to the medical staff to be under the influence or having withdrawal symptoms. Occasionally, someone will get knifed in the parking lot, that sort of thing. That's what usually starts these prosecutions. After the Lee case is this Cheney case. Now, this is a little older. This one is 2019. It was brand new the last time we did this session. Another husband and wife team, though. Here you had 240 separate counts in the indictment. El Chapo and Al Capone didn't have 240 counts, nothing near that in their federal indictment. Now, it was whittled down to a mere 40 counts for trial, but still, either these are very serious cases or we have got rampant over prosecution going on in every jurisdiction in the country. I know which one I suspect that it is, but I always like to present the countervailing viewpoint as well. This was a 25-day trial. again, the longest case I ever tried was one of the death penalty murder cases, and it went on for 22 days. This one went on for 25 days in federal court. The interesting aspect of this Cheney case to me is as follows. The defense wasn't that I wasn't prescribing inordinate, huge amounts of controlled substances. The defense wasn't that I was really giving them a thorough medical examination. He wasn't. The defense was, as it turns out, several of these patients had need of these drugs. They had underlying medical conditions. Not that it was revealed through his examination, but in this case, Sixth Circuit said that doesn't hold any water. Otherwise, a doctor could go out and find random people on the street corner and write prescriptions for them. And in those cases where it turns out they had some medical need, even unbeknownst to them, that would be a defense to it. This case also illustrates this legitimate medical purpose. This is the standard. And when I first read the Ruan case that we're going to conclude with in just a moment, I thought, have they changed the entire yardstick by which these cases are measured? Is the legitimate medical purpose, scope of practice, is that all out the window now? I've concluded no. That's still the CFR, that's still the governing law, and it still is going to be proved by circumstantial evidence, in my opinion. Again, the difference is going to be how the jury is instructed. Instead of the jury being instructed during closing arguments, if you find beyond a reasonable doubt the defendant knowingly and intentionally prescribed, comma, and if you find beyond a reasonable doubt that those prescriptions were outside legitimate medical practice, then you should convict. And now it's going to be only if you find beyond a reasonable doubt that this defendant knowingly and intentionally prescribed outside of the normal course of legitimate medical practice. It's a mens rea. I don't see a case that we're looking at here today, again with my apologies for flicking through the slides quickly, but I've got all the notes of key points. Nothing that's really important is escaping us, and you can go back and look at the slides at your leisure later. But here is where the Sixth Circuit there is saying, we don't care that they had underlying medical conditions. What we care about is whether you, doctor, were prescribing within your authority. And your authority is as follows: pursuant to a legitimate medical need and a doctor-patient relationship, which means you examine them and apply your medical judgment. The Rowland case this is actually an unpublished case from the 11th Circuit in 2018. Another husband and wife team here. And this doctor worked at 4 Atlanta area clinics. 3 of them were owned by the same non-physician. That strikes me as a flag. I know that a lot of medical facilities are owned by groups or individuals that have no medical training at all. But it's striking to me as I look through these federal cases, the number of times those are the ones who wind up being prosecuted and facing federal prison time. The facts here are the usual facts. 10 to 20 patients a day. $300 if you're a Georgia resident, $400 if you're not. Out-of-state tax, I suppose. And the patients here were given price breaks if you brought other patients in. They were to sponsor, in much the same way that other non-medical businesses will give you a gift certificate if you bring 3 friends or make referrals, etc. What I want to do is skip past a couple of these cases here, which are more examples. The Elliott case. Well, you get the feel for what a court's going to do on these appeals many times by reading the opening paragraph. And here, the opening paragraph of this opinion describes the facts of someone. This, according to the 6th Circuit here, this was the place to go in Broward County. The patients were recruited from all over, from Ohio, I think mostly from Kentucky, Ohio, Georgia, even Massachusetts. I was involved in a case in Oklahoma one time where there were, in essence, busloads. Now, what it was 4 or 5 carloads at a time would come up here from North Texas. They'd do it once a month. They'd all ride together and get prescriptions, not only for their own addictions, but to sell as well. Now, back in those days, that was, just south of 30 years ago, Demerol and Dilaudid were the drugs of choice that they were always seeking back then. I hear very little about Dilaudid these days. Again, I don't swim those waters much anymore. Elliott's another example of one of these cases where you see inordinate, enormous amounts of controlled drugs being prescribed, the number of patients being seen, mostly run as a cash business, etc. I want to go past these two. I've only put 3 cases up here that go beyond the prescribing, where you've got prosecutions for homicide. And I mean either manslaughter or murder. It seems to me in the last 15 years, these have become more commonplace. It could be that we're seeing more examples of deaths that are directly attributable. It could be that prosecutors have become more adept, or at least less wary of trying to prosecute a doctor for the death of another, when it was the doctor's, at least apparently authorized prescribing that caused that. This case is seeing, I had this the last time that we did this, both this and Stiller, and conceivably every other case, there's going to be 1 or 2 commonalities here. In Oklahoma, our felony murder statute actually allows first-degree murder if a death results directly from unlawful dispensing or distribution or delivery. I've always secretly thought that that was an accident. I've always secretly thought that when the legislature amended the felony murder statute in Oklahoma, that they meant distribution and delivery, but they didn't necessarily to mean murder 1 for unlawful dispensing, which usually is prescribing outside the bounds of the legal authorization. Most of the prosecutions you see elsewhere, and of the 2 that I was involved with in Oklahoma, 1 out of the 2 are usually second-degree murder. So first-degree murder, I've not done a state-by-state comparison. I'd be surprised if very many states allow first-degree murder for inordinate prescribing that causes a death. Oklahoma technically does. Whether a prosecutor chooses to pursue that or not is another matter. Usually, though, what you're talking about is second-degree murder or manslaughter. And again, the exact elements vary somewhat from state to state, but not a lot. By and large, you're talking about the following. On second-degree murder, either a murder that emanates directly from the commission of some felony. In this case, it would be felony unlawful prescribing, or what we might call depraved heart murder. Even though no death of any particular person was intended, the behavior evinced such a lack of regard for human life that they should have known that death was likely to result. That's why it's called depraved heart murder. And then it can be manslaughter, which is culpable negligence or a death that results from being in the commission of, or attempted commission of some misdemeanor. So again, I apologize for being a little discombobulated on those slides, but the long and short of what we've just looked at here is as follows. There are a plethora of cases out there where practitioners have gone to federal prison. One of those that I didn't dwell on, the guy got 2 life sentences consecutive to 240 years. 2 life sentences consecutive to 240 years. And those aren't rare prosecutions. They're more common now than they have been, at least in my judgment, over the last 15 or 20 years. And as I've tried to highlight, they emanate, usually in my opinion, from getting involved in what turns out to be a lucrative area of practice. It doesn't require a lot of overhead, and the amount of money that can be generated is enormous. Now that I've given you all this good news, at least the Ruan case comes back, and perhaps Ruan injects more of a subjective element into these than the objective. And here's what I mean. All along, as I've said twice now, the burden of the prosecution has been to prove beyond a reasonable doubt that they prescribed intentionally, and usually through expert testimony, that it was way outside the bounds of their legal authorization, such that they should be held accountable for it. Ruan says, and I think this Ruan case is probably one of those that's going to wind up in textbooks for law schools, not so much on controlled substances or drug prosecutions, but on the more arcane element of the difference between an element or a affirmative defense, or on this issue of mens rea, and how do you determine what piece of the statute the mens rea points to. In Ruan, again, the facts were fairly consistent with everything we've seen here today. There actually were two companion cases that were tried together. Ruan's lawyer wanted the jury instructed that they had to find beyond a reasonable doubt that he intentionally broke the law. The numbers involved, the money and the amounts of controlled substances were every bit as shocking as you see in some of the others. And his defense here, to read now, I'm very sorry. To prove that a doctor is unlawfully dispensing and that it falls outside the statute's prohibition now requires some element of intent as to the illegality. As a matter of fact, once the defendant / doctor proves that they were authorized, because again, the statute prohibits prescribing without authorization. Once they show that they have authorization, which is to say that they have the authority to prescribe, then the burden shifts to prove not only that they did something that the law views as wrong, but that was their intent, that was their knowledge all along. There's that CFR again, and it defines legitimate medical purpose. On the companion case to Ruan, it wasn't tried together. The Supreme Court took the two of them together, as they frequently do when they're making law. In the companion case, it was a good faith defense. The defendant's lawyer said the jury should be told that even if everybody agrees that the prescribing was unlawful, indeed, even if we now agree after hearing all this, the question should be at the time that it happened, was he prescribing in good faith? Was she prescribing in good faith based upon what they thought was their best medical judgment? Now, of course, the trial court rejected that. That's why it got to the US Supreme Court. The US Supreme Court rejected that. Interestingly, some version of that is actually where the government wound up. At the US Supreme Court, some version of wanting a good faith defense is actually where the government wound up urging the Supreme Court to go. And the US Supreme Court said, that makes a lot of sense to us. The problem with that is, in neither 21 USC section 841 nor the CFRs that accompany it, in nowhere is the word good faith used anywhere, objectively, subjectively, or otherwise. And that is why the majority here, and this was a case without dissent, this was the majority opinion here, opted for this mens rea must go to the authorization. You must prove that it was the intent to violate the law, not just the result. There were 3 concurring justices. They agreed with the outcome that the jury was misinstructed here, that it's not enough to show that you intentionally prescribed and that it also violated the law. But those 3 concurrences, they would have gone with a more good faith, objective good faith. Measured from an objective standard, did they act in good faith? And again, that's not the law. That was what the 3 non-winners would have held. What does it all mean? Well, I believe that what I've told you is in some regards insider baseball. It makes a lot of difference to the defendants here. It will make a difference to their lawyers in the future. After having considered this for a few months, and we'll see how shiny my crystal ball is in the end, I believe that perhaps in marginal cases where you have very qualified experts opining that this prescribing was outside the law, but where the numbers are not just shocking. By numbers, I mean 1 million dosage units of CDS in a given year. In one of those cases, over a 4-year period, the two partners made $7.6 million just off of that pain management practice. When you have something short of that, I can see where it might be more likely to result in an acquittal, where the jury has more difficulty finding, not so much that this violated the law, but that he intentionally did it. On the other hand, when you have cases like the ones that we've illustrated today, and I dare say, like the facts in Ruan and the companion case were, it will surprise me if this results in a great deal more difficulty in proving those cases and in a great deal more acquittals. And we'll see if I'm wrong or not. As I told you at the outset, I went through just to see what's happened since then. And what I find as recently as this morning was the US Supreme Court has actually reversed convictions on 5 of these types of cases from the 11th Circuit and the 6th Circuit. What they've done is recently as last Monday in 2 of them, they've just summarily reversed the conviction, sent it back and said, reconsider this in light of the Ruan decision. Beyond that, all I can find are a few trial level decisions. I've seen a couple of attempts to apply Ruan to non-drug cases, trying to enhance maybe the government's burden on proving intent. I've seen a couple of motions trying to get their case dismissed pre-trial based on Ruan because the indictment doesn't specifically coincide. And in both of those, the federal district court has held the indictment as worded is sufficient to allege consistently with the Ruan. And in the end, we'll just make sure that we so instruct the jury. So where are we? I don't believe that the legal jeopardy for those who crossed the line is any less than it was. I do believe that the government's burden is going to change. I don't think that it's going to, and this opinion has changed since the Ruan case first came out. But upon reflection, I don't see it changing the complexion of these prosecutions a lot. I think that you are still going to have the case hinge largely upon hopefully qualified experts who have reviewed the records and find that this is so far outside the bounds of law that the practicing physician knew or should have known what they were doing was wrong. And in the end, that's the only way you can ever prove intent, is by looking at the behavior and asking a jury to infer the intent from that. My apologies for the few rough edges on this, but I assure you that everything that I wanted to say got said, and you have 72 or so slides that you can look at your leisure, and I'll be available for questions, I think, at the appropriate time. Thank you all very much.